just as a friendly reminder, we are the Cancer Legal Resource Center. We're a joint program of the Disability Rights Legal Center and Loyola Law School. All of our services are free and confidential. We do have the capacity to assist people in both English and Spanish, and we also utilize a language line when people call us with questions who do not speak English or Spanish. The other really important thing to know about the CLRC is that we do follow an education model as opposed to a litigation model. So we really focus on educating patients, caregivers, healthcare professionals, and everyone in between about what their rights are. So like I said, we are a joint program with the Disability Rights Legal Center and Loyola Law School, and one of the major programs that the CLRC has is our National Telephone Assistance Line. If I'm not able to answer any of your questions or some of your questions today during the webinar, you can please feel free to follow up with us either on our telephone assistance line over the phone or through our online intake system. The phone number is 866-THE-CLRC, which is 866-843-2572. And then we also have the online intake form, which is clrcintake.org. So rest assured, hopefully we will be able to answer your questions today, but if not, you can always follow up with us. So let's dive right in here. Advanced planning obviously can be a difficult topic to talk about because nobody really wants to think about death. But as we know, today is tax day. The only two things in life that are certain are death and taxes. So planning ahead can ensure your wishes are upheld and prevent problems down the road. So some of those problems could be someone making healthcare decisions for you that you would not have made for yourself. Advanced planning can help avoid family conflict and anguish for your loved ones once they're left behind. So it's really important to document your wishes in writing. Even if you think that everyone, including your friends and family, knows what you want, if it's not in writing, then who knows what could happen. You know, it makes it a lot easier for you. It gives you peace of mind, but it also gives your friends and family peace of mind knowing exactly what it is you want. So today we're going to talk about advanced planning in sort of two different contexts. So the first part of the presentation today is going to be about people and property. So we'll talk about the tools that you can use to protect your assets, decide who gets what when you die, which is, you know, your property, and also designate someone to manage your property and finances if you've become unable to do so. So the second part, we'll talk about advanced planning in terms of your health care. We'll talk about the tools that you can use to document any specific wishes that you may have concerning the treatment you want and don't want in a medical emergency, and to name someone to make healthcare decisions for you if you become incapacitated. So tools for planning ahead with respect to people and property. The three main tools that we're going to talk about are wills, living trusts, and powers of attorney for financial affairs. And again, the requirements from each of these really do vary depending on what state you live in. So if you do have more specific questions about what makes each of these documents valid, please feel free to contact the CLRC after the webinar. So when we're thinking about our property, the first step is to think about your estate. You know, a lot of times advanced planning is referred to as estate planning. I think the term estate planning maybe makes it sound like it's only for people who have huge estates, like Downton Abbey, you know, owning multiple properties, and you have a whole staff of people attending to you. Generally, when we're talking about someone's estate, it can be large, it can be small. You know, you don't have to own property, real property. Your estate could be just whatever the clothes are in your closet and whatever furniture is in your apartment. So when we're talking about your estate, it's really just the things that you own. It doesn't necessarily mean that you are, you know, wealthy or low income. Everyone has an estate. So your estate, like I said, consists of all property or interests in property which you own. And the simplest examples are those assets which are in your name alone, such as bank accounts, real estate, stocks and bonds, furniture, jewelry, stuff like that. So once you have an idea of what property you actually do own and what share of property you might own, you can begin to think about who you would like to give your property to once you pass away. And one thing that I do want to flag for you also is that on our website, which is cancerlegalresourcecenter.org, we do have several advanced planning handouts, including a couple of handouts which I believe are called personal records file and taking care of business forms. Those are pretty simple forms where you can just sort of list out all of the different properties that you own, just to have it all in one spot, and that can be helpful when you're starting to think about, you know, creating a will or a trust. So you know what you have, so you know who you can give it away to. So once you have an idea of what are all of the different things that you own, you have to think about how do you own it. Because you can only give away something that is entirely yours. So if you own a share of something, you can only give away your share. So for example, if you and your brother purchase a boat together, when you're thinking about who you want to have that boat, you wouldn't be able to give the entire boat away. You'd only be able to give away your share of it because your brother still owns half. So there are two different types of ownership. There is sole, and then there's joint. And joint ownership is owning something with another person, and all of your names are generally on the title to that property. So joint ownership comes in a couple different forms. There's rights of survivorship, there's joint ownership as community property, and then there's, you know, others. So joint ownership with rights of survivorship means that when one of the owners dies, the other owner takes full ownership of the property automatically. So none of that property is inheritable. And the most common example of this is when two people who are married buy a house together. In a lot of states, that is presumed, the house is presumed to be owned with joint ownership with rights of survivorship. So if one of the spouses dies, the other spouse automatically owns the entire thing. Community property, on the other hand, is determined by state law. Not every state is a community property state. California is, for example. But community property means that all property accumulated by two spouses during their marriage becomes joint property, even if it was originally acquired in the name of only one partner. Each spouse owns one half of the couple's property in community property states, and therefore when a husband or wife dies, only one half of the marital property is inheritable since the surviving spouse owns one half of the marital property. If this doesn't apply to you, if you don't live in a community property state, don't worry about it. If you're not sure whether you live in a community property state, you can always contact the CLRC and we can look into it for you. So, you know, property laws vary from state to state. It's important to find out what types of ownership rules apply to any property that you own either individually or jointly so that you know how much of it you can potentially give away when you are making your plans. So one very common advanced planning document is a will. A will is a document where you basically lay out who you want your property to go to when you pass away. But there are formalities to create a valid will. So, for example, some wills do have to be signed by two witnesses, And those two witnesses have to be what's called disinterested. That means that they can't be people who are going to be receiving anything under your will. So for example, if you were planning on leaving everything to your son and daughter would not be able, neither your son nor your daughter would be able to be witnesses to that will because they have an interest in making sure that they would get all that property. It would have to be maybe a neighbor who isn't planning on, who you haven't left anything to in the will. But the rules about what constitutes a valid will, again, are determined by state law, varies from state to state. So if you have questions about your state, contact us. The safest and most effective way to create a will is generally to have your will prepared by an attorney. A qualified attorney can make sure that your will reflects your wishes and is in compliance with state laws. If you are looking for an attorney to complete a will for you, don't be afraid to ask up front about costs. So most estate planning attorneys deal with these matters on a regular basis. This is a will is sort of their bread and butter. So they should be able to tell you what you should expect to pay, and so feel free to shop around. Some attorneys will charge hourly for will preparation. Others will charge a flat rate for a will. So rather than, okay, 3 or 4 hours worth, it doesn't matter how long it's going to take, they're going to charge you, let's say, $500 or $1,000. But again, obviously that'll vary from attorney to attorney. So it's a good idea to sort of shop around. And then, if you are low income or have, low assets, there are often free will preparation services either at legal aid organizations or sometimes attorneys will offer to do that pro bono for free. So depending on how complicated your estate is, how complicated your how many different types of property you own, or that sort of thing, it may or may not make sense to have an attorney, to pay an attorney to create a will for you. If your estate is very simple, a statutory will, which is basically a form will, could also potentially be an option. So some states do have something called a statutory will form, which is a form that is created by the state and then written into state law. Residents can use those form wills at no cost, but they have to be used exactly as they are written. So you just fill in the blanks with your own information. Not every state has a statutory will form, and so generally to find out whether your state has a statutory will form, you can consult your state bar website, or you can also give us a call. And I know that there are also websites that sell will forms. We don't necessarily here at the CLRC have an opinion on those one way or the other, but I would say that if you're looking for a form to sort of just fill in the blanks, it's probably a good idea to check and see if there's a free form that's provided by your state before looking into purchasing a form. Oh, okay. Looking into purchasing a form through one of those other websites. Another option in some states is something called a holographic or a handwritten will. So obviously if it's handwritten, that means it's in the person's handwriting. It has to be in the handwriting of the person who is who is creating the will. They usually do not have to be witnessed as long as the entire thing is in the person's handwriting. There can't be parts of it typed. The whole thing has to be written out. But again, it's not recognized as valid in every single state, so it's a good idea to check and see what the requirements are for valid wills in your state before you go ahead and just write it out in your handwriting. the other really important thing to think about when you are coming up with, your planning for either creating a will or some other type of advanced planning, it's a good idea to reassess any previous planning that you've done. So maybe you created a will 15 years ago, but a lot of things have changed since then. It's a good idea to go back and look at that to see whether or not something needs to be updated or if you need to create an entirely new document. The other pretty common assets that people sometimes forget about when it comes to advanced planning is, life insurance policies, IRAs, if you have a retirement plan or some sort of annuity. For those types of assets, they generally ask you to name a beneficiary, so to name the person that money would go to once you pass away. And so sometimes you'll forget about that. Maybe you signed up for a life insurance policy, again, 10 years ago. Maybe that was when you were still married, and now you're divorced, and maybe you don't want your ex-spouse to be receiving that money anymore. Or maybe you have had a child, and you've decided that you no longer want your sister to be the beneficiary. You want to make sure that, your son or daughter is the beneficiary for one of these assets. So it's a good idea to review pretty, periodically to see whether something has changed, just so that, your planning reflects your current situation as opposed to maybe where you were years and years ago. So sometimes people ask us about, maybe they have created a will years ago and some things have changed, and so they want to know, okay, well, can I just amend the will or do I have to create an entirely new one? The easiest way to amend a will is to create a completely new one and void the old one. That will often make things less confusing, and you run fewer risks of voiding the entire document or having two conflicting documents that make things, a little uncomfortable. But what counts as voiding a will also varies from state to state. Sometimes you have to destroy it. Other times you have to write on it and write the word void. So that's information, again, that you can easily find online or by contacting your state bar or the CLRC. A will can also be changed through something called a codicil. And a codicil is a legal document that must be drafted and executed in accordance with the same state laws which apply to wills. A codicil is simply an amendment to your will. And so because you have to follow the same rules that you would follow for creating an entirely new will, if, for example, your state requires 2 disinterested witnesses to make the will valid, you would also need 2 disinterested witnesses to make the codicil valid. So generally speaking, you can't just, cross or handwrite something onto the old will to update it. You would still need to follow the same formalities where you would maybe print another page, have 2 more people who are disinterested witness and sign it. It probably has to be dated. So if you're already going through all of those formalities, for some people it might just be easier to just create an entirely new will. And so I sort of mentioned this before on the previous slide, but you should really review your will when there are major changes in your families, such as births, deaths, divorce, etc. But also when the value of your assets significantly increases or decreases, and also when you purchase or sell a piece of real estate. So you don't want too many major life changes to have taken place without updating your advanced planning documents. And then if you move to another state, you will generally also have to make sure that your will complies with the new state's laws. So it might be a good idea to talk to an estate planning attorney in that new state if you do move. So what happens if you die without a will? If you die without a will, this is referred to as dying intestate. State law will determine at that point where your estate will go, who gets all your property. There is generally a list of heirs that is preset by law that courts will reference to distribute your belongings. And while that can be good, it also might not reflect who you actually would have wanted to receive your property. So, for example, if you die without a spouse or children, your estate might go to your parents if they're still alive instead of to your brother or sister. If you would have preferred to have all of your property distributed among all of your family members, including your brother and sister, if you don't have a will, you don't really have any say in who that property goes to. But again, this is true except for life insurance policies, joint accounts, property that's held in joint tenancy with right of survivorship, because for those assets and for those types of property, you've already designated who is going to receive it upon your death. But generally speaking, if you die without a will, your spouse and children receive it first, and then the next closest kin would receive it. So regardless of whether you have a will or if you die intestate, your estate will go through a process called probate following your death. Probate is the legal process by which your estate will be administered. And in addition to making sure that the executor, so sort of like the manager of your estate, correctly distributes your property to your heirs or beneficiaries, it also provides for the determination of whether or not your will is actually valid, and then also if there are any claims by creditors against your assets at your death. So, if you have a whole bunch of money that you're trying to give away to various family members, but it turns out you owe a lot of money in medical bills, during probate is when the hospital might be able to come after your estate, and they would potentially be paid first before your family members got any money that was left over. Probate can be costly because there are attorney's fees, there are sometimes statutory fees, sometimes the executor will get fees based on how much time they're spending, and then it can be time-consuming as well. And the other thing that can be a little bit of a turnoff for some people about probate is that it is public, so the provisions of your will and the value of your assets do become public record. So one way to avoid the probate process entirely is to create a trust. There are many different types of trusts. Some common types of trusts include a charitable remainder trust, which is where the remainder of trust property that's left over upon your death would go to a charity. Some people will leave everything to the Red Cross or the American Cancer Society or something like that. Another type of trust is a testamentary trust, which is one that you set forth in your will to provide for your children or others who need management of their assets. And then there's also the most common type of trust, which is the living trust. So a living trust is a written agreement where you name beneficiaries and include instructions on how you want your property distributed to your beneficiaries upon your death. You are the one who's creating the trust. You're called the trustor or the settlor. You also name the person in charge of managing the trust, known as the trustee, who is responsible for distributing the property in the trust directly to the beneficiaries. You can name yourself the trustee of the trust until your death, when the assets of the trust will go to your beneficiaries. Once created, the trust must also be funded, which means that you have to transfer assets from your name to the name of the trust. So that means Deeds to real property must be prepared and recorded. Bank accounts have to be transferred, and stock and bond accounts transferred as well. Trusts are more commonly created for more complicated or larger estates. You know, a lot of times people who own a house or you know, multiple properties, they'll change the name on the deed to the trust, and then that'll make it easier for the property to be transferred. A living trust is more expensive to have drafted than a will because it does require quite a bit more preparation and a lot more effort to set up. But once the trust is created, there's no court supervision of this distribution process like there is under a will, so it can be faster and less expensive than distributing assets under a will. So if you have a trust, the estate is not going to go through probate. It doesn't become public record. There are no fees once the trust is created. So, you know, there are pros and cons to both estate planning documents, and so it's a good idea to talk if you're not sure, if you think maybe your estate is somewhat complicated or large enough where you're not really sure what type of document is better, that's when it can be a really good idea to talk to an estate planning attorney. And again, you know, when it comes to costs for setting up a trust, it's a good idea to sort of shop around to different estate planning attorneys, because again, some of them will say, okay, we'll charge you a flat rate, and that includes amendments. Others will say we'll charge hourly, so you know, you'll have to make that determination based on what's better for you. If you do have a living trust set up, you might still want a will known as a pour-over will. A pour-over will directs any property that is not already in your trust to be put into the trust at your death. So for example, if you buy a car or other property during your life and you don't go through the process of placing the new property in your trust as you acquire it, so if you just put the car in your name instead of in the trust's name, you would need to have a pour-over will to make sure all of your property ends up in the trust. So all of those documents are talking about, you know, what are you going to do with your property upon your death? But what if you need help managing your property right now or before you die? So a power of attorney for financial affairs is a legally binding document that you prepare or have prepared for you to sign, where you choose a trusted person known as your agent to act for you if you become incapacitated. And incapacity means that you are unable to act or speak on your own behalf, and it's generally determined either by a doctor or a judge, depending on the state. And generally speaking, powers of attorney do need to be signed and notarized in order to be valid. They end as soon as you pass away, so your agent wouldn't have authority over your financial affairs after you die unless you also happen to have named them as the executor of your will or the trustee for the trust. So if you have a will, once you pass away, that's when the will goes into effect or the trust goes into effect. Before then, you can appoint an agent by having a power of attorney for financial affairs. So the two most common types of powers of attorney for financial affairs are durable and springing. So if you want your agent to start making decisions for you today, and for that agent to continue making decisions for you when you become incapacitated, you would create something called a durable power of attorney. It's durable because that means it's lasting even when you're not able to make decisions. So sometimes a spouse might sign a durable power of attorney and say, you know, I want my wife to be able to access my bank accounts and manage my financial affairs because I'm currently in the hospital. And even though I have the capacity, the mental capacity to handle my affairs, I can't make it to the bank, so I'm going to give her financial power of attorney as well. So a durable power of attorney will start now and stay in effect when you become incapacitated. If you want your agent only to be able to act once you're not able to make your own decisions, that's when you would create something called a springing power of attorney, because it sort of springs into action when some event occurs. And in this case, the event would be you becoming incapacitated. I think that's generally the more popular one. You know, I might not necessarily need my brother to be managing my financial affairs right now, but if I became incapacitated, that's when I would want him to be able to access my bank account. And one more practical tip here, when we're talking about powers of attorney for financial affairs, often banks will have their own forms in addition to some sort of financial power of attorney that you might have already have signed. So it's a good idea if you're thinking about nominating someone or naming someone as your agent, and you do have a bank account or a mutual fund or something, you might want to check with your bank or with your stockbroker or whatever to see if there is some other form that they require. Not that they wouldn't necessarily honor the financial power of attorney, but sometimes if you fill out those specific bank forms ahead of time, that will make the process a lot easier. There will be fewer hoops for your agent to jump through. Okay, so now we're going to change gears a little bit here and move towards tools for planning ahead with respect to healthcare. We're going to talk a little bit about advanced healthcare directives, living wills, powers of attorney for health, and physician orders for life-sustaining treatment. And again, these all vary depending on your state law, so the CLRC is happy to answer any questions about what makes these documents valid in your state. So my understanding is that tomorrow is National Healthcare Decisions Day, so that's sort of why we wanted to focus a little bit on advanced healthcare directives here today. Advanced healthcare directives are written instructions that state your wishes about the medical care and treatment you want to receive if you're unable to make medical decisions for yourself. They are intended to avoid unwanted care, reduce suffering, and ensure that your wishes are honored at the end of your life. Generally, an advanced healthcare directive must be signed and dated in the presence of 2 witnesses. And usually those witnesses cannot be your healthcare provider or anyone that works for your healthcare provider. So if you're in the hospital and you need to create an advanced healthcare directive, it can't be your doctor signing it as a witness. It can't be one of the nurses. It can't be anyone else that's employed by the hospital. In some states, notarization might be required, and then in other states, it's usually either 2 witnesses or notarization. That's how it is in California. Every state now it recognizes advanced directives, but again, the law does vary from state to state. And they have different names in different states. So in some states, it's just called a living will. But most advanced healthcare directives combine living wills with a power of attorney for healthcare decisions. And then they can also include information about organ donation and primary care physicians. So some advanced healthcare directives, depending on your state, might have 4 different sections. Some might only have 2. It just varies from state to state. So the first part of an advanced healthcare directive or it can be called a living will. And a living will is different from, the type of will that we were talking about before, which says where you want your property to go upon your death. A living will is a written document that allows you to give explicit instructions about the types of medical treatment that you would want to be administered if you become unable to speak for yourself. So a living will can be very specific or very general. More specific living wills may include information regarding an individual's desire for pain relief and the use of ventilators or other life-sustaining treatment. Maybe this is where you say that you would not want a feeding tube, or you would want heroic measures taken. It just depends on your personal preferences. So another part of an advanced healthcare directive is a power of attorney for health. So a power of attorney for healthcare names someone, similar to a power of attorney for financial affairs. This is where you name someone who you trust to make medical decisions for you when you are too sick or injured to make them for yourself. A power of attorney deals with all medical decisions unless you decide to limit it, which you can. You can also give specific instructions about treatment you want or don't want, or about other issues that might concern you. So when deciding who you want to make healthcare decisions for you, what's most important is that you trust the person to honor your wishes, and that you feel confident discussing your wishes for medical care with him or her. Your agent need not agree with all of your wishes, but has to respect your right to get the type of treatment that you want. So, for some people, for some young people, for example, it can be a lot to put that type of pressure on a parent. If you were going to name your parent, they might have a harder time, for example, withholding, if you say that you don't want a feeding tube, for example, you might not trust that your parent would follow your wishes. So maybe a sibling would be a better choice, or maybe your best friend would be a better choice. Maybe if someone who you were very close to doesn't agree with your point of view about certain types of medical care, maybe that person might not be the best choice to be your agent. So what if some people do unfortunately name agents who refuse to follow their wishes? So what if the person you choose is unable or unwilling to act as your agent? You can always name an alternate. So sometimes that person is unavailable. Maybe you live far away from your family member who you've named, and they cannot show up at the hospital at the very moment that the doctor needs a decision made. It's a good idea to name an alternate, maybe someone who is close by, in case there is an emergency like that and your primary person is unavailable. But we would say that it's a good idea to avoid naming more than one person as your agent at the same time. So you wouldn't want to have two co-agents. Sorry, I'm having a little technical difficulty here. Okay, perfect. You wouldn't want to name more than one person at the same time, because if they disagree about what your wishes would be, then that just further complicates the whole situation. So it's a good idea to name one person who you trust and then have a backup alternate. Another tool for planning ahead for your health care is called the Physician Orders for Life-Sustaining Treatment, or POLST. Similar to an advanced directive, because it does address pain management, resuscitation, and feeding. But the POLST is a little different because it's completed with the approval of both the patient and the physician. It has the force of a physician's medical order, and it remains with patients wherever they receive care. It is in there in your medical records at the hospital. It's on this bright pink piece of paper so that hopefully the doctors or nurses will not won't miss it. It's easily attached to the patient's chart. So that makes it a little different from the advance directive, because your doctor might not have a copy of that, and maybe your family might not even know where your advance directive is, which is why it's a good idea to talk about all of that stuff with your family or your close friends. So, be sure to let people know that you've created these documents if you do decide that you want to create these. And I did see that there was a question. We will be posting the PowerPoint slides on our website along with this webinar recording. So rest assured, if you want to share this with family or friends or patients or coworkers, you will be able to do so. So more than 40 states have or are developing PULSE programs, so you can easily look into whether or not your state has a PULSE program if you check out this website. So why would you want to plan ahead for your health care? Well, in every state, people who are at the end of their lives do have certain rights regarding end-of-life treatment, and planning ahead ensures that your rights will be protected. So some of the rights that people have at the end of their life include the right to palliative care, which is care that focuses on pain management and pain abatement rather than on prolonging life. Patients have the right to refuse food, including through a feeding tube. They always have the right to refuse medical treatment. They have the right to palliative sedation, which is basically where people are sedated to the point where they do not feel the pain, which can help allay people's fears about pain if they know that they have this right if it gets too bad. And they have the right to have their wishes upheld, so their advance directives or PULSE enforced. These types of decisions can be extremely difficult for both the patient and his or her family, especially when the patient and family members do not agree with the course of treatment or lack thereof. This is why it is important to document your wishes in an advance directive or PULSE so that you know that your wishes are going to be upheld even when you might no longer be able to make the decisions for yourself. I think the main reason why it is so important to have this written down is because even if you 100% trust your agent and your agent knows exactly what your wishes would be, chances are they still care about you a lot, right? And so it's either way, it's probably still a difficult decision for them to have to make a choice like this, even if it's what you would have wanted. Because, right, if it's to only give palliative care and not to prolong your life, chances are they would still want you around. If it's all in a document written down, and they know that has the force of a physician's order behind it, or if they know that this is a legally binding document, it will make their decision or their it'll make it easier on your family members if they are if all of your wishes are made very clear and in writing ahead of time. So some states also give patients and their doctors the right to death with dignity, which is also referred to as aid in dying. The states that do have a right to death with dignity generally have specific procedures for making and granting such a request. If you do have questions about aid in dying or the right to death with dignity, you can always contact us here at the CLRC. There's also a really good organization called Compassion and Choices, where they have a lot of great materials on end-of-life choices and provide free counseling regarding those issues. So the states where that's currently, where patients can currently access aid in dying is Vermont, Washington, Oregon, New Mexico, Montana. in California here, we are, the Disability Rights Legal Center actually is working on a case trying to provide access to patients here as well. So if you have more questions about that, you can always contact the CLRC. So what if your loved one did not plan ahead? What if they become incapacitated and there was no advanced healthcare directive, there were no financial powers of attorney? What can you do to assist your loved one? Well, there's something called conservatorship, and in some states it's called guardianship, and that's a judicial procedure that appoints someone to take charge of a person's legal, financial, and personal affairs when they are deemed not legally competent. To create a conservatorship, a petition may be submitted to the court by someone who is asking to be appointed as the conservator. It can be a spouse, a relative, a friend, or even an interested state or local agency. The petition must contain information on why the individual cannot manage his or her financial affairs or make decisions concerning his or her personal care. And then the court will conduct an investigation and hold hearings to determine if the person is actually incapacitated and whether appointment of a conservator is required. Obviously, if you have to go through the court system, there are fees associated with this. There are, you know, it obviously does not happen overnight necessarily. So we really, really want to encourage people to plan ahead of time so that their family members are not faced with these situations where they're forced to have to go to court in order to be able to manage someone's affairs. You know, and the other thing that I didn't mention is that there are statutory financial powers of attorney, and often there are also advanced healthcare directive forms that are available online for free. So here are a couple of resources that I want to share with you. The first is Caring Connections. They have advanced healthcare directive forms for free for download for every single state in the U.S. They have a quite thorough instructions for how to fill them out. So that is a really, really good resource if you are looking to create an advanced healthcare directive. Compassion and Choices is the organization that I just mentioned. They do free counseling on end-of-life care and treatment. CancerLegalResourceCenter.org, that's our website. We have some advanced planning documents on our website, and then we also obviously have our telephone assistance line and our online intake form. And then, you know, almost every state bar has a website that has information about advanced planning. So, you know, whether there are statutory will forms, financial power of attorney forms, or, you know, even just referrals to local attorneys who might be able to assist, you know, it's a good idea to check with your local state bar. Okay, I'm happy to take any questions if there are any.